Hi, everybody. Thanks for attending the St. Mary's County Library presentation, Article 2, the Judiciary. So this is part of an ongoing series about the creation of the U.S. Constitution, and tonight our speaker, Dr. Jim Gibb, will be presenting on, of course, Article 3 of the U.S. Constitution, which is all about the establishment of the federal judiciary system, including the Supreme Court and lower courts. Before we get started, I just wanted to quickly introduce myself for anyone who might be new here. My name is Allison, and I work for the St. Mary's County Library System. All right, I think that's all I've got. And Jim, if I know we normally have you say something brief about your background, if you wouldn't mind doing that really quickly, that would be great, just in case anyone new is
Sure.
here.
My name is Jim Gibb. I'm an archaeologist. As of this month, I've celebrated my 50th year as an archaeologist. I am not an historian. I'm not a constitutional historian. This series is more about me exploring the Constitution myself and then sharing it with others. Um, I don't have the last word on any of this. Indeed, nobody has the last word on our Constitution. That's why we have a Supreme Court. All right, I'm going to share my screen. So I want to start off with this. The, the Virginia Resolve, and there was another one I'll get to in a moment. Both of these were issued by Virginia and Kentucky in 1798. And the reason I wanted to mention them up front is they have a little bit to say about the court system. And here again, as usual, you don't have to read these. I will read them anyway. So the General Assembly of Virginia doth explicitly and peremptorily declare that it views the powers of the federal government as no farther valid than they are authorized by the grants enumerated in that compact, that is, the Constitution. The General Assembly doth solemnly appeal to the like dispositions of the other states in confidence that they will concur with this Commonwealth in declaring, as it does hereby declare, that the acts aforesaid are unconstitutional. This is James Madison writing the Virginia Resolves in 1798, and it's in response to two laws passed by the federal government, the Alien Act and the Sedition Act. And in the opinion of the leaders of Virginia, those laws are unconstitutional. And here, Thomas Jefferson, writing for Kentucky, says that the several states who formed that instrument, the Constitution, being sovereign and independent, have the unquestionable right to judge of its infraction, and that a nullification by those sovereignties of all unauthorized acts done under color of that instrument is the rightful remedy. So Jefferson's putting a name on this. It's called nullification. For those of you who know anything about Civil War history, that's what the states seceding from the unions did. Uh, they embraced the concept of nullification. And that theory is that if federal government passes laws that, in the opinion of these other states, any one or more of them, in their opinion, it's unconstitutional, then they don't have to abide by that law. So there are a couple of questions that grow out of this. Um, One of which is, did the several states form that instrument? And one of the points that I think we need to make is that the states did not ordain the Constitution. The people of the United States ordained and established the Constitution. They did so through conventions held in their various states. The state legislatures, the state governments had nothing to do with the Constitution. And there's the question, can the states individually or separately ignore or nullify an act of Congress or a Supreme Court decision? Is there a final arbiter of the Constitution, the fundamental law? Is there a final arbiter as to what that Constitution means? So that's really what drives this evening's discussion. A few other quotes I want to bring up. It is emphatically the province and duty of the judicial department, that is, the federal judiciary, to say what the law is. And this is from an opinion by Chief Justice John Marshall in the case of Marbury v. Madison, which I'll be discussing in a few moments, 1803. So in this particular decision, Chief Justice John Marshall is saying it's our job to do this, to decide what the law is, to interpret the Constitution. In a quotation that's attributed to President Andrew Jackson in 1832, and this had to do with dealing with the Indian nations in Georgia, John Marshall has made a decision, now let him enforce it. So this is the President of the United States saying that he's not compelled to obey the Supreme Court. A quote that's definitely from him, from a letter he'd written: "The decision of the Supreme Court has fell stillborn, and they find that they cannot coerce Georgia to yield to its mandate." And then finally, this quote from the Federalist number 78 by Alexander Hamilton in 1787, 1788. "The judiciary has no influence over either the sword or the purse. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm for the efficacy of its judgments." So this is a piece written, excuse me, to encourage the people of New York State to ratify the Constitution. But it was read up and down throughout all of the states. So he's saying that the judiciary, the only power they have, the only thing they've got going for them is judgment, and that they have to rely on the executive department, the president, to implement their decisions. Frankly, I find that a little worrying, but so anyway, that's all kind of a long wind up to get to tonight's talk, the judiciary. This is part 7 and 9. So we're going to wrap this up in May. Those of you who've been to the previous two talks are familiar with this slide. The U.S., where I talk about the Constitution, except the 27 amendments, and put them aside, consists of roughly 4,500 words. The number varies depending on whether you include headings and whatnot. It's not very long. Only 9% of the words in the Constitution are devoted to Article 3, which is all about the federal court system. And there are only 3 sections in it, as opposed to, say, 10 in the legislative portion of the Constitution. But Article 3 delineates the organization powers of the judiciary. One of the big problems at the Constitutional Convention, which, to remind you, ran pretty much from late May through middle of September in 1787 in Philadelphia, 4 long months that these guys struggled to put this thing together. A common refrain amongst the sort of skeptics was they were afraid that a federal judiciary would usurp the power of the states, particularly the courts. And that's something I'll bring up as we go along, but it's very clear to me that a number of the delegates to the Constitutional Convention did not understand that a federal judiciary would deal with federal law, not state law. So I'll bring that up again as we go along. So we're going to focus on this Article 3 and then talk a little bit about Chief Justice John Marshall and his take on the Constitution, on what it means. So again, you've seen this chart before, breaking it down, number of words, percentage of words, and percentage of sections. The Article 3 got short shift. Article 3 got relatively little attention, and you'll see why. In the convention, the Committee of the Whole debated the judiciary on June 4th and June 5th, which is early in the convention. It's about a week in. They came pretty quickly to a consensus that there would be a Supreme Court, but they were really at odds about the value of inferior courts, what we now know as the federal district courts and circuit courts. And so the way, as you'll see, the text, the way they dealt with that is it said, look, Congress has the power to the Constitution will create the Supreme Court, but Congress has the power and authority to create inferior courts and also to lay down a number of rules for the Supreme Court. So constitutionally, all those other courts you always hear about, the U.S. Court of Appeals and all that, those aren't in the Constitution. Those are products of of statute law, Congress passing laws. A lot of question about who would pick Supreme Court justices. Would it be the legislature? Would it be the executive? Would it be the Senate? And the solution they came upon was that the president would nominate, the Senate advises and consents, and most of us are probably familiar with that process. The president will nominate somebody for justice, and then the Senate has to hold hearings and then say yea or nay. When they're talking about, in the Constitutional Convention, they were discussing the character of prospective judges. They did not talk about the knowledge of the law of those prospective judges. These are guys who need to know the law because they're going to be applying it when they adjudicate cases. Why do you think that would be so? I mean, why weren't they concerned about the legal knowledge of these judges? And since we're doing this via Zoom and not in person, it's a rhetorical question, and I will answer it for you. And that is that at the time in 1787, when the Constitution was being drafted, there was no federal law. There was no law to adjudicate. There was no law that needed to be executed by the executive branch, and there are no legal cases to be adjudicated by a federal judiciary because there were no federal laws. So there was no law to be knowledgeable of. One of the debates they were having is, and this gets back to last month talking about Article 2, the executive branch. A lot of people were concerned about the president being able to unilaterally veto legislation. And so some folks had suggested, well, how about we have a council of revision consisting of the president and of the judiciary, the Supreme Court or members thereof, who would examine each law passed, each bill passed by Congress, and decide whether or not it was constitutional. Elbridge Gerry doubted whether the judiciary ought to form a part of it, as they will have a sufficient check against encroachments on their own department by their exposition of the laws, which involve the power of deciding on their constitutionality. In some states, the judges had already been doing this. They've been deeming some state laws as against the constitution of their respective states. He moves to postpone the clause in order to, quote, that the national executive shall have a right to negative any legislative act which shall not be afterwards passed by parts of each branch of the national legislature. So here's Elbridge Gerry saying the judges don't need to be involved in this. The president can veto, and then some percentage of the House and of the Senate can then vote to override that veto. Rufus King seconds the motion, observing that the judges ought to be able to expound the law as it should come before them, free from the bias of having participated in its formation. So the judiciary has no role in legislation. Now, this may seem obvious to folks, but it wasn't at the time. But nowadays, there are lots of folks who talk about judges legislating from the bench. So let's look at Article 3. Again, it's pretty brief, one section at a time. Section 1, really simple. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may, from time to time, ordain and establish. The judges, both of the Supreme and inferior courts, should there be any, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So the key things here are one Supreme Court. Doesn't tell you how many people are going to be on that court. It doesn't say anything about a Chief Justice. Inferior courts would be established by Congress, and they're not by the Constitution. In fact, the Judiciary Act of 1789, which is one of the first laws passed by the new Congress, had to do with setting up the federal judiciary system that we know today. The compensation would be periodic, could not be lowered during their tenure. It could be increased at the discretion of Congress. What that means is that you couldn't leverage justices by threatening to lower their salaries. Tenure uh, is during good behavior. A judge can be impeached by the House of Representatives, tried and convicted by the Senate, and removed. This is true of cabinet officers as well as, of course, president and the vice president. In our history, there have been, I'm going to say, 15 impeachments of judges and 8 convictions. So it's fairly rare. That's over 230 odd years. So what constitutes good behavior? I mean, the Constitution's kind of vague on that. Well, it's not vague, it just doesn't say. Judges can be removed for high crimes and misdemeanors. And one of the earliest, well, the earliest was a district court judge in New Hampshire named John Pickering, who was impeached and convicted for drunkenness and profanity on the bench. A sterling career. Uh, Congress can also pass a law that removes the judge, if that judge is convicted in criminal court without there being any impeachment. Remember, impeachment is not a criminal proceeding, it's a political proceeding. So Congress has the power to structure and create the inferior federal courts. It can repeal a law that created a particular court. And that happened in 1802, where the incoming Republican Congress, if you may recall, John Adams served one term as president from 1796, well, 1797 to 1801. And partly because of the passage of the Alien and Sedition Acts in 1798, the Federalists lost the presidency. They lost both houses of Congress. They did still have a number of their Federalists in serving as judges. John Adams tried to create new judgeships, which Congress passed, the Federalist Congress passed. And what the Republican Congress did the following year is they passed a law that got rid of those judgeships, not the judges, but their positions, their courts. And without the courts, they were out of jobs. John Marshall was the fourth Chief Justice of the United States, and he was the first one who really took the life tenure seriously. He served from 1801, when he was appointed by John Adams at the very end of Adams' term, until he died in 1835. And he made quite a splash during those years. Just for a visual break in the text, we have granted, a restored Supreme Court chambers occupied by the Supreme Court from 1810 to 1860. The Supreme Court is required to meet at the seat of government. So in the early years, the Supreme Court met in New York, And then when the capital moved to Philadelphia, they met there. When they moved to Washington in 1800, the Supreme Court met pretty much in the basement of the Capitol building, or in a committee room. In 1810, they moved up to what became the old Senate chamber because the Senate had new chambers built for them upstairs. So they occupied that. And this is a restored view of what it looked like. And this is a view of the second floor Senate chamber that the Supreme Court then occupied when the Senate had yet a new place built for them. So the Supreme Court met in this room from 1860 to 1935 in the Capitol building. This is a branch of government that did not have its own building. Just a floor plan of what it looked like. It was pretty cramped quarters, given the number of cases they would be hearing in a very short period of time. It said the Supreme Court met as a Supreme Court just a few weeks, a couple of times out of each year. So there were a lot of people there for cases, a lot of clerks, a lot of lawyers, pretty crowded. This is an 1885 cartoon meant to be a critique of the Supreme Court chambers. And in white at the top, I've indicated what these little signs to the right and below. Cases unadjudicated, 1880 to 1882, in this room here. Cases adjudicated only in 1883 in this room. You've got this mail carrier, stuff falling out of his box. Each of these cases is labeled important or appeal or something to that effect. If you look, I don't have a high resolution image of this, but if you look carefully at what's written on these things, that's part of the joke. That basically justice is not being served because these justices do not have the room or the staff to take care of the load before them. In 1935, during the Great Depression and Work Projects Administration, a new Supreme Court building, which is what is used today, a home of their own. Section 2, powers of the judiciary. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, that means not just the Constitution, but statute law, and treaties made or which shall be made under their authority. This is amended by the 11th Amendment, the first one after the Bill of Rights in 1795, to make a bit of a change. So it affects all cases affecting ambassadors, public ministers, consuls, etc. All cases of admiralty and maritime jurisdiction. You can't have the states creating and enforcing maritime law. That comes under the national government. Controversies to which the United States shall be a party. And one of the examples I could give of this is that, I work at the Smithsonian Environmental Research Center in Anne Arundel County. We have neighbors. If we have a property dispute with one of our neighbors, it doesn't go to state district court. It goes immediately to federal court, the federal district court. So what seemed like a small local matter of property ends up becoming basically a federal case. And controversies between two or more states, the idea being that if one state court is deciding a matter between two states, there's a perception that it will be biased towards their own state. The original Article 3 also says between citizens of different states. That is, if somebody in Virginia had a case against somebody in Maryland, it would go to the federal court. That was eliminated by the 11th Amendment in 1795. It just becomes unwieldy. And then between citizens of the same state claiming lands on the grants of different states. Section 2, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. What that means is if there's a case that meets those criteria, the Supreme Court sits as the original court, deciding on matters of law and fact. In all of the cases, which is the majority of the cases that come before the Supreme Court, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Remember, Congress, under Article 3, really can make up all kinds of laws about governing the judiciary. Uh, that's how our Supreme Court is usually operating. Cases are heard in lower courts in the federal system, and if they're appealed, they finally make it to the Supreme Court. Also, cases at state level, if there's a constitutional issue involved in deciding those cases too can eventually make it up to the Supreme Court. So original jurisdiction of the Supreme Court with national government, foreign governments, or representatives, or two parties. Supreme Court doesn't have exclusive original. It could an original jurisdiction could find its way in the lower federal system first before coming to Supreme Court. They hear appeals of decisions by lower courts. That's mostly what the Supreme Court does. It relies on lower courts to ascertain the facts and the relevant laws. And if a case comes before the Supreme Court, and the court finds the facts wanting, the law misapplied or misinterpreted, they could remand that case back down to the lower court, and probably to the court where the case was originally heard. Trials of all, this is in Section 3, doesn't really necessarily govern specifically the Supreme Court, but the trial of all crimes, except in cases of impeachment. Remember, impeachment's not a criminal thing. It's a civil proceeding. Shall be by jury, and such trial shall be held in the state where the said crime occurred, where it was allegedly committed, but when not committed within any state, the Congress will decide where that trial is held. If you recall from what we were talking about, the Declaration of Independence this time last year, the Crown had passed laws prior to the Revolution that brought some cases from the colonies back to London to be decided. That meant people who could potentially be witnesses would have to find their way across the Atlantic to testify and back again, taking many months. And so people, those cases that were brought back to England generally would be dismissed. Treason. This is something that comes up in our political dialogue a lot nowadays. So-and-so is guilty of treason. Article 3, Section 3 specifically defines treason against the United States as consisting only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. So what does this mean? A person who's accused of treason they have to be levying war or aiding enemies of the U.S. Now, what constitutes levying war? What constitutes enemies of the United States? I think to those folks at the time, it was pretty self-explanatory. The Constitution, Article 1, says that only Congress can declare war. But obviously, in United States history, since the mid 20th century, we've been at war a lot without Congress declaring war. So I think the very fact that, if you're dropping bombs on somebody, that's war. And so, in order to be guilty of treason, you would have to have aided the enemy in a time of war. There need to be at least two witnesses that have to be testifying to the same event. They can't be testifying to two separate acts of alleged treason. Well, I mean, they can, but that won't be enough to convict. And then Congress determines, this is subsection 2, Congress determines the punishment, but they cannot punish the family of the person convicted of treason. They cannot take all that person's property if there's family. Uh, the son of somebody convicted of treason has the same rights as any other citizen. They're not precluded from running for office or doing anything else. In the old world, prior to the revolution, that was not the case. The son was guilty of the sins of the father. And you see references to that in the Bible. Uh, yeah, Merchants of Venice, Shakespeare, there's some talk about that. We sometimes refer to sins of the father. The Constitution, this is not the only place where it mentions it, but there can be no bill of attainder. You cannot basically take all the property of somebody convicted of a crime, the crime of treason. Oops. So let's look at the Supreme Court and basically what it can do, in the inferior courts as well, beyond what the Constitution says. Because again, we just went through Article 3. We're done. That's all she wrote. So creating the inferior courts. Um, the Judiciary Act of 1789, very early on in the first Congress, may have been the first law they passed, actually. There'd be a chief justice and four associate justices. A quorum would require at least four of the justices. That is, the chief justice and three other justices. I suppose you could have a quorum with just four associate justices. They would meet again in the capital, the nation's capital, February and August, for a few weeks in February and August. There'd be 13 judicial districts in 11 states. District of Columbia didn't exist for another 11 years. Remember, North Carolina and Rhode Island had not yet ratified the Constitution. When George Washington became president, when he was inaugurated, I think April 17th, 1789, only 11 states had ratified. So he was president of only 11 states. And so we didn't have federal courts in the two missing states, North Carolina, which ratified in November of 89, and then finally Rhode Island, often referred to at the time as Rogue Island, because they were always running rogue, not till spring or summer of 1790. So there are 13 district courts. Massachusetts had two districts, one of which was Maine, which was at that time part of Massachusetts, but considered a separate district for the judicial purposes. Virginia also had two, one of them being the Kentucky district, Kentucky eventually becoming a state like Maine some years later. So each new state would then be designated a district. There'd be 13 district courts with a district judge presiding over lesser crimes, admiralty cases if it's a maritime state, and small suits against the national government. There'd be three circuits, so those 13 districts would be grouped into three separate circuits. Each circuit would have a district judge and two justices, by which we mean two Supreme Court justices. They would have original jurisdiction for major crimes and lawsuits and anything involved in the United States as a plaintiff. And they would also be the appellate court overseeing the district court decisions. These circuit courts would have a district judge and two Supreme Court justices. That means those five justices would have to spend their time between the February and August sessions traveling around the districts to which they were assigned, to the circuit courts to which they were assigned, hearing cases. So they'd be bumping along the roads for weeks on end in terrible transportation, sharing beds and inns full of lice and bad food. It was just really kind of nasty for these guys. The act also established the U.S. Attorney General, which did not exist. It's not one of the cabinet offices originally, and the U.S. Attorney and Marshal for each judicial district. So here's those districts. The Eastern District, Vermont did not yet exist. It was part of New York State. Maine, again, was part of Massachusetts. The middle states, Pennsylvania, Jersey, Delaware, Maryland, um, West Virginia did not exist at the time. It was still, part of Virginia. And then the southern states. So each of those districts had to be covered by those two justices in a district court. And that was the case until the Judiciary Act of 1891. So for 100 years, Supreme Court justices were circuit riders. And they'd be going around for months between those two sessions in Washington hearing cases. Eventually, they went to one justice for each new district, and then circuit court justices for the current 11 districts. I'll get to that in a moment. But you could see these guys were going around hearing cases, not at the district level, but at the circuit court level. They'd make decisions. People who did not like those decisions could then appeal them to the Supreme Court. Well, who would sit on the Supreme Court? Two of the justices whose opinion they were appealing. So this was not an ideal situation, but it remained the case for many years. Today, we have this map. It shows the U.S. divided into 11 circuits, and you'll often hear this on the news. Such and such a case was decided by the Ninth Circuit out of San Francisco, or the 11th Circuit down in Southeast. Each circuit is assigned a Supreme Court justice, and I have them all on there. So the very Northeast is presided over by Justice Jackson. Sotomayor oversees New York, Vermont, Connecticut. Alito has Pennsylvania and New Jersey and Delaware. Justice Roberts, he's going to stay right in Washington, D.C., so he has the lower mid-Atlantic and upper southern states. But you'll see Alito also has the Fifth Circuit, which includes Texas, Louisiana, and Mississippi, generally regarded as our most conservative circuit court. So he's overseeing these two circuits. Justice Kavanaugh also has two. He's got the Sixth, which is the upper middle Midwest, and most of the Plain states. And Justice Kagan has most of the western United States. If you look below, Alaska and Hawaii as well. Puerto Rico comes under Justice Jackson. The U.S. Virgin Islands come under Justice Alito. So now these are administrative. I've not researched it. I don't know exactly what they do, but they are basically are the administrators for each of those circuits. Chief Justice Roberts, of course, oversees everything. And the proper term for the Chief Justice is not Chief Justice of the Supreme Court. It's Chief Justice of the United States. The Chief Justice presides over the entire federal judiciary, not just the Supreme Court. Again, I think a lot of that's administrative. We have this quote here from John Jay, who is our first Supreme Court Justice. lasted 5 or 6 years. Um, John Adams, before leaving office, nominated him to be Supreme Court Justice again. And he had resigned first time. He says, such was the temper of the times that the act to establish the judicial courts of the U.S. was in some respects more accommodated to certain prejudices and sensibilities than to the great and obvious principles of sound policy. Expectations were nevertheless entertained that it would be amended as the public mind would become more composed and better informed. I left the bench this first time perfectly convinced that under a system so defective it would not obtain the energy, weight, and dignity which are essential to its affording due support to the national government, nor acquire the public confidence and respect which, as the last resort of the justice of the nation, it should possess. Basically, he's telling Adams he doesn't want the job because it sucks. A lot of travel involved. They don't get their own building. It's rather undignified. The first three Supreme Court justices resigned. No other Supreme Court justice since then has resigned except for William Howard Taft. After being president, he became Supreme Court justice. He retired and then died later that year in 1930. I'm going to try to move this up a little bit. So I will skip that. We'll start with John Marshall. He was the fourth justice. He died in office in 1835. Previously, he was Secretary of State for the outgoing John Adams administration. Prior to that, he was a representative for Virginia. Before that, he served as an officer during pretty much the entirety of the Revolutionary War. He's known for many cases, but best known for Marbury v. Madison. And this is a really crucial case. And I'll tell you the story. Adams had lost. It was kind of embarrassing. Uh, and he was trying to secure at least the judiciary as a stronghold for the Federalist Party. And so he got Congress, the outgoing Federalist Congress, to create 42 new judgeships. And sort of, like the last day out, he's got these judges uh, confirmed by the Senate, and he's got their commissions written, signed, and sealed, and ready to go. John Marshall, who was Secretary of State, well, just accepting his commission as Chief Justice, he was responsible for delivering those commissions to the various judges. He neglected to deliver, I don't know, 10 or 11 of them. So they left on his desk. The new incoming president, Jefferson, told his Secretary of State, James Madison, don't deliver them. One of the people appointed for the district as a justice of the peace was a guy named William Marbury. He petitioned the Supreme Court for a writ of mandamus. And this is a writ that goes from the court to a agency and tells them basically to hand over a document. So telling the Secretary of State he had to deliver that commission to William Marbury and I think three others who were in the suit. In Marbury v. Madison, it was a unanimous decision by the justices, but Marshall wrote it. And he said William Marbury is entitled to the commission. It's a legal right. It's basically personal property that he owns. A writ of mandamus is the appropriate remedy that's available to the courts. And the Supreme Court has the constitutional authority to review and execute executive actions and legislative acts. Okay? But there's a big however there. We're on point number 4 here in the slide. He said the Supreme Court lacked the authority to issue the writ because in Section 13 of the Judiciary Act of 1789, it gave the Supreme Court the right to issue that writ. But the Constitution, Article 3, Section 2, subsection 2, does not. That part of the Judiciary Act of 1789 was unconstitutional. And so Marbury did things the right way. He went to what the Act of 1789 said he could do, and that is go to the Supreme Court, which would have, according to that act, original jurisdiction. Had he gone to a lower court in the federal judiciary, he could have gotten that writ. And then the government would have had to honor it or basically reject the court or appeal it. And that appeal would go to the Supreme Court, which then constitutionally could entertain that case as an appeal, and they could decide. But Marshall said, nope, we don't have the authority. That part of the Judiciary Act is unconstitutional. In this somewhat labyrinthine case, this is a very small part of it, but it's a very important part because in it, Marshall is saying that the Supreme Court gets to determine the constitutionality of a law. And he says, and I shall read it, it is emphatically the duty of the judicial department to say what the law is. And this is the phrase you'll often see in various sorts of public discussions about the Supreme Court. Those who apply the rule to particular cases must, of necessity, expound and interpret the rule. If two laws conflict with each other, the court must decide on the operation of each. The Constitution is either a superior, paramount law, unchangeable by ordinary means, we could amend it, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter it. And that's what he's saying they did with the Act of 1789. They're basically changing what's in the Constitution. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not a law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable. Certainly, all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. And that's from his decision of 1803. Now, mind you, Congress put off the meeting of Congress of the Supreme Court by a year. In 1802, Congress, the now Republican Congress, eliminated those courts that the Adams administration, Federalist Congress created. So basically, those jobs didn't exist anymore anyway. Frankly, as someone not trained as a lawyer, I don't know why Marbury just didn't ask for back pay, because whether or not he actually received the commission seems moot. It was courts were created by Congress. The Senate approved Adams' nominations. The commissions were signed and sealed. Basically, they're operative. You don't actually need to have it in hand. It's like saying you need to have your marriage license on you or you're not married. It's all been done. So the implications of this are U.S. Constitution is fundamental and paramount law. This is not a political document like the Declaration of Independence. The U.S. Constitution is essentially our first and our foundational law. Number two, the Supreme Court determines the constitutionality of laws and government actions. Now, the President of the United States can say something's unconstitutional. The Speaker of the House could do the same. I can say the same to my neighbor over the backyard fence. But what the Marbury v. Madison decision says is that the Supreme Court is the final arbiter of what the Constitution means. And this has been very clear in court decisions since the mid-20th century. I say Contra Dahl. This is a fellow whose book I've recommended earlier with reservations. Judges do not legislate from the bench. They determine the constitutionality of laws and government actions. They compel adherence to the law, and they invoke remedies for violations. The people, that's us, through our elected representatives, we can change the laws and amend the Constitution. So if a law is found wanting by the Supreme Court, there's always the option of Congress taking up that law again and revising it so it does meet constitutional muster. And this has happened recently too, where the Supreme Court has even told Congress what they need to do to make that law constitutional. Alternatively, the Constitution can be amended. But the Supreme Court decides what's constitutional and what is not. The judiciary has neither sword nor purse. So how does it enforce those decisions? Um, Let me just show you this quickly. This is from the Pew Research Center looking at favorability since 1987 of the Supreme Court. Unfavorability started at 76% and has worked its way down to 48%. And it's been a little bit of a rough ride in there, but it's definitely a downward trend. Unfavorability has increased. And you can see one place where it really starts dropping is around 2001 when the Supreme Court, I would say, interfered in the Florida Supreme Court in Bush v. Gore. They took a case that, in my opinion, they didn't need to. The Florida Supreme Court was determining, whether or not there would be recounts and when those recounts would have to be finalized for the election of 2000. But this is not a good trend because remember, the Supreme Court doesn't have any divisions behind it. It doesn't have any military behind it. It doesn't have the purse strings. It can't, like Congress, just say, okay, do what you want, but we're not giving you any money. The Supreme Court really relies on public opinion. If we look at it by party, Republicans and those leaning Republican, again, from Pew Research Center, there is, with Republicans, there's some significant drops in around 2016 and a rise, and it's still dropping down to 71. With Democrats and those leaning Democrat, it's been declining and a significant drop in the last 5 years. So can the Supreme Court continue to operate if it doesn't have the people behind him? Remember, Richard Nixon, he was going to be impeached. He left office. It was unnecessary to impeach him. After the Supreme Court ruled that he had to surrender those tapes, those incriminating tapes, he couldn't hide behind executive privilege. That's what the Supreme Court said. And the outcry in this country, and I remember it well, was such that Republicans in Congress convinced Nixon to resign because otherwise he would be impeached. But that Supreme Court, their decision was really enforced by Vox Populi, by us. Anyway, that's all I have for tonight. Next month, going to talk about Articles 4 through 7. There's some important stuff in there. I've been revising this talk a little bit, and including Article 5, which is about amending the Constitution. So that's all I have for tonight. I'm going to skip over a little bit, but I'm happy to answer any questions.
Hi, Jim. It's Emily. I was curious, the 11 districts, when a new judge comes in, are they just given the district that the judge they're replacing had, or does it get shuffled around, or how does that work?
In the justices, I
Yeah.
think they are assigned by the Chief Justice. He decides who gets what districts. The Congress decides what those circuits are, and it decides what those districts are, whether or not to create new districts, meld together old ones. But the Chief Justice decides, Chief Justice assigns circuits to each of the justices, the 8 other justices on the court. Now, you might have noticed, a very conservative judge gets assigned the very conservative district, a very liberal judge gets assigned.
I did notice that. That's what I was wondering.
It's hard. It works with the Southern District, but not with the Western one, because Justice Kagan, one would consider from the liberal wing of the court, and yet, yeah, it includes San Francisco and California, but it includes a lot of parts of this country which are far from being liberal. It's a way of dividing up the pie. Um, how they do it, I don't know. I suspect there are some numbers involved, like how many cases, how many districts are in each of those circuits, because uh, it has nothing to do with the Constitution, which we're talking about. It's not something I've researched, but you can certainly go at it. None of this information is secret. You could probably Google anything you wanted. Any other questions? You all satisfied, huh? So when you see the news tomorrow night, you'll know exactly what's going on.
Uh, Not, how about more frustrated?
Yeah, as I said before, the whole Constitution relies on this concept of human behavior that the framers had, and they assumed that each branch, including the two parts of the legislative branch, would guard their rights and privileges jealously. And they would use the Constitution, they'd hit the other branches over the head with the Constitution to ensure that everybody follows it. What they did not envision was a branch of government that would basically roll over and die. And this is not something that's just happened. It's been going on certainly throughout the 20th century, where we have the rise, Arthur Schlesinger referred to as the rise of the imperial presidency, where we tend to look to the president as telling Congress what to do. At the State of the Union address, this is going on for years, the president has been telling Congress what he wants done. That's not how the founders envisioned it, the framers. Congress, the president's supposed to execute the will of Congress. And yet, over the years, the president has become the central focus of our government, not Congress. All right. Well, if that's it, I'll see you all next month. I hope, if I've driven you all away.